Thank you, Your Honors. Bo Bowen, Bowen Law Group, on behalf of the defendant, Mr. Probst. I'm sorry, the appellant, Mr. Probst. If I could have 5 minutes for rebuttal.
Okay.
Thank you, Your Honors. The issue in this case, primary issue in this case, is whether or not the bank had competent evidence to support both their judgment and the amount of the default in this case, primarily attacking the loan payment history that was relied upon by the bank in this case.
So before you kind of move into your hearsay argument, can you address the fact that that loan payment history was entered into evidence with no objection?
Yeah. I know the trial counsel. He's a very agreeable guy and tries to come to agreements whenever possible. He did agree initially to the admission of a lot of this evidence, and I think all of the evidence in, but that was before any examination into the evidence that elicited the reasons why one might object as on hearsay. And as soon as the information came out that indicated that this in fact was unreliable hearsay, he did raise the objection at that point.
But it was already in evidence, correct?
Yes. Well, BSI's loan payment history was in evidence. And we have an issue with that loan payment history as well. What wasn't in evidence and was not stipulated into was the information that was recorded by the prior servicer. What BSI was saying in this case is that they received this loan from a prior servicer. I think it was Equifirst, if I remember the name correctly, that serviced this loan, and there was 3 years worth of loan payment history that not only did they not bring to court with them, they couldn't bring. They can't bring it, so no one can examine it. Why that's important is...
Just to follow up on her concern or question, once you stipulate to the admissibility, you've agreed to the predicate. Can you be heard to complain later?
I think you can, Your Honor, when further evidence comes out that disqualifies, let's say it was a testimony that came into evidence without objection, and later on there was some kind of evidence that the person contradicted themselves or something comes out, there's grounds for striking testimony, there's grounds for striking evidence that's come in. At the time,
was there a
this was
motion to
introduced.
strike?
I'm sorry?
Was there a motion to?
It wasn't worded as a motion to strike, no, Your Honor. It was just an objection to the testimony because it relies on hearsay. And to that point, even if the testimony at trial was that BSI's loan payment history necessarily incorporated, and the starting point for BSI's loan history, I forget the exact date, it's November of 2010 in that time range, the beginning date, the beginning entry of the amount due on that loan came from a prior servicer. That is hearsay because that prior servicer's records aren't in there. They weren't in evidence, and the witness said they can't be produced at all.
Well,
and
there has been case law, though, that's dealt with this issue. There's the, I think, Bank of New York Mellon case out of the 4th, and it talks about when you have this issue, you have a prior servicer, you bring it in, now you have a new servicer, and they're electronically transmitting that payment history, and it laid out kind of a list of things for the trial court to look at. How do you think that doesn't apply, and what did they not do in this case to verify that?
For clarification, are we referring to the Callaway case from the 4th DCA, or is this the one that...
Vessels.
I'm sorry?
Bank of New York Mellon, I believe, versus Vessels.
Vessels. Is that, I'm sorry, it might be, is that the one that was just cited by...
I'm sorry, Callaway.
Callaway,
yes.
Thank you very much.
You were right.
I could go on probably a 30-minute diatribe about my disagreements with Callaway.
Okay. But right now it's the 4th DCA.
It's the 4th DCA, and I think that kind of dovetails into some of my argument here. In that case, the Callaway court held, and this court has followed to an extent in the Berdicia case, but kind of distinguished itself on one factor that I get into. The Callaway case held that not only did the plaintiff, the subsequent server, not really even have to verify the prior server's information, didn't even have to know anything about how the record's created. The Callaway court said that these loan transfers, these transactions are inherently reliable. They're inherently reliable. That was one of the bases for its opinion. And keep in mind that we all know about the former robo-signing scandal where banks were falsely testifying in affidavits to these very same loan transactions. And now you have a fourth DCA that says, no, they're inherently reliable. You don't have to know how the records were kept by the prior servicer, the circumstances under which they were kept, nor do you really have to verify it. This court, although Imbridicia adopted somewhat of the reasoning in Callaway, it did find that, in the distinction of footnotes, said that the subsequent servicer in the Imbridicia case actually worked for the prior servicer. That's relevant because he would have had some knowledge of the prior servicer's record-keeping procedures and how they were kept and maintained in the ordinary course of business. That is much different than one company that was servicing the loan just does a file dump over to the other company comes in and says, no, I don't know how those records were kept by the prior servicer, and by the way, I can't even produce the prior servicer's records. You're just gonna have to trust me that they're accurate, and that when we use their information as our starting figure, they're accurate because I said they are. There is nothing in the rules of evidence that says self-serving evidence, self-serving testimony as to the accuracy of evidence makes it admissible. The business record exceptions lays out the circumstances, and that's what's important when you look at the business record exceptions.
Well, isn't the ultimate issue whether the documents are trustworthy or reliable, and wasn't there some discussion or evidence presented regarding boarding and how the information was gathered, evaluated, determined, and ultimately found to be accurate?
Trustworthy is an element, but if you look at the rules, the evidence code for the business record exceptions, trustworthiness comes in only after you set the other factors. You know, when was it created, the time the event's recorded, in the ordinary course of business. Then after all of that, if for some reason it's still not trustworthy, it can be disregarded. It doesn't say you skip all that stuff, and then if it's trustworthy, you let it in anyways.
What issues then do you, what part of the predicate then do you take issue with?
They can't lay a predicate whatsoever for the information that came over from the prior servicer because, one, there's no testimony they ever worked for the prior servicer, had any knowledge of the record-keeping procedures, and in fact can't even produce their documents. We don't even know that Equifax ever serviced this. We don't know who they are. They didn't present any evidence. They didn't bring any of their information over. They're just saying, trust us that when we got this information that you can't see, that the homeowner can't cross-examine, that it's accurate because we said it is, even though we can't tell how it was created.
But didn't they have a check and balance when they went through the boarding process, though, to determine accuracy? And then provide testimony?
They do.
They're
but
particular.
I'm sorry. And even going to your point, and I think it's back to the Callaway, even in Callaway and Imbridicia, where you say you have this boarding process, they still had the loan payment history from the prior servicer admitted. There was no case until recently that said, and I think they cited as a supplemental authority, there was no case until recently that said, yeah, that boarding process eliminates the need to even produce the prior servicer's records. I mean, you at least had those to examine so you can look at them. They didn't even do that in this case. And their own, going back to BSI, their own loan payment history, they're the only ones that have the records that go back to the date of the alleged default in this case. And this is at record 472. Their own loan payment history they testified to wasn't assembled, recorded, and put together till a year later.
But none of this was already in evidence. So the trial counsel, which I understand that was not you, had not actually, I mean, he had seen this paperwork prior, correct?
Correct.
And he didn't object to, at any point, its admissibility on the basis of, for instance, the discrepancy in the date or any of that. It just was admitted.
Correct.
Correct.
And then later, once, again, I don't want to repeat myself, but yes, once the facts came out, that gave rise to a valid objection.
And what were the facts that came out specifically that he didn't know ahead of time?
Right. One, that there was a prior servicer that they weren't going to include records for.
So he hadn't received records prior to trial.
I'm sorry?
He hadn't received any records of prior servicers prior to trial.
I wasn't party to it, so I don't know.
Okay. So
but you would, it's the bank's burden to introduce all their evidence, and if they fail to bring that evidence, it doesn't matter that you didn't see that it was excluded prior to trial. It's their burden to bring it that day. So when he found out that this was actually piggybacking off other records that weren't being introduced, that gave rise to an objection. Also, when he found out under their direct examinations, it wasn't even under cross, under their direct examination, the plaintiff's attorney asked, when were these records recorded, assembled, and put together, or language like that. It was a year later. He said at the time.
If we conclude the objection was belated, what is your best argument in this case for a reversal?
I'm sorry?
If we conclude that the objection was too late,
Yeah.
what is your best argument for a reversal in this case?
Best argument would be, again, this is sufficiency of the evidence and whether this is competent substantial evidence. I think on the face, why is hearsay evidence, why is it excluded? Because it's inherently unreliable. He made an objection if it was untimely. That doesn't change the character of this evidence that they're relying on as being inherently unreliable. Maybe we can't go back and exclude it, but where subsequent information comes out that shows that this evidence is unreliable, that it is based upon and piggybacks upon an admissible hearsay that was not even introduced to the court, I don't think if it's not excluded, it's definitely not competent substantial evidence to support a judgment.
Doesn't that go, that issue, doesn't that go to the weight, kind of the credibility of the loan payment history? And that would be something the trial court is usually in the best position to weigh. That's not something that we don't weigh the credibility of that evidence. That's what the trial court does. And is that kind of what you're asking us to do?
No, well, I struggle with the difference between weight of evidence and sufficiency of the evidence. I think sufficiency goes to the character of the evidence rather than weighing against other things. I think the character of this evidence is just not reliable. You have a witness that tells you on direct and on cross that, yes, we created this document a year after the events recorded, a year after the default they're alleging in this case. This document was created a year later. And they're telling you that this piggybacks off of a record from a prior servicer that we can't produce. I've never seen anywhere where a witness, until recently, where a witness is allowed to say, not only do I not know how the prior servicer kept their records, I can't produce them for you. Just trust me that they were accurate when we uploaded this. That doesn't meet any, that's a bridge too far, I think. That's would obliterate the rule against hearsay and the business record exception.
I just had a question. Was this witness deposed before trial?
I don't know the answer to that, Your Honor.
All right.
I would reserve the rest of my time unless the court has other questions for me at this time.
All right, thank you.
Thank you.
Good morning. May it please the court. Daria Laberhamy with Greenspoon Martyr on behalf of the appellee. The final judgment should be affirmed. We raised it in our brief and we raised it in our first argument, and I'm going to reiterate the point here. The appellant has waived any argument that the evidence admitted was hearsay. At trial, counsel failed to timely and contemporaneously object to the admission of the payment history, the payoff panel, and the documents supporting the amounts in the final judgment, and they've waived the right to argue that it was hearsay on appeal.
Well, I think what they're saying is at the time they looked at the document, they assumed it was from the loan servicer that was coming to testify. As it was revealed during trial that they had onboarded this other information, they realized there might be a hearsay issue. So at that point, do you think that based on this new information they received, they couldn't make an objection at that point?
I believe they had to make it contemporaneously before the documents were entered into evidence without objection. They had the opportunity to voir dire the witness before it actually went into evidence. They could have asked the questions, what are these documents? Why are the documents from prior servicers? Why are certain documents missing? They didn't object. It came into evidence, and the documents and the amounts set forth in the documents support the final judgment. And it goes to Your Honor's exact point. The judge had the opportunity to weigh the evidence. The evidence then goes to weight, and whether or not the judge finds the evidence supports the amounts in the final judgment.
Well, let me ask you this. I mean, it might be more directed to a case in the future, but let's assume there was an objection, a timely objection. And the person says, well, we get this data by computer or whatever, but we don't print it out, or it can't be printed out or whatever. I mean, that's kind of an odd situation.
Well, I think the trial judge, he properly analyzed the issue. He said the witness testified they get documents in two different formats. They get it in electronic format, they get it in paper format. And just because it came over in electronic format and they're not able to print it anymore doesn't mean they didn't receive the information and that it wasn't properly boarded in their system. That's what the judge said during the trial, and that's how he analyzed the issue.
Well, I know the judge did say that, but he said that I get a lot of stuff on computer. I haven't used court files in a long time, and I get that. But But on the computer, you get to hit print if you want something printed.
I think you reconcile that by the case we filed as supplemental authority last month, where the bank didn't have the first couple of years of the loan payment history from the prior servicer, and the fourth DCA said it doesn't matter. As long as there's competent, substantial evidence to support a prima facie case for damages, you're entitled to, it got reversed and remanded for a new trial, but there's evidence to support a final judgment for damages. So whether or not the bank got the records in a paper format from the prior servicer and are able to print it out doesn't really matter to entitle the current foreclosing plaintiff to a final judgment based on a prima facie case for damages. Here, there was documents from BSI, the current servicer, with at least their payment history, and there was the payoff screenshot, similar to the Eisenberg case, that showed the principal, the interest, the default going back to September or October 2011 to warrant damages in this case. And that's what the court entered as final judgment based on, in addition to the fact that the borrower didn't, or the attorney, not appellate counsel, didn't contemporaneously object to the admission. There was competent, substantial evidence to support the damages in this case, and we asked the court to affirm. If there's any questions, I'm happy to entertain them.
All right, thank you.
Thank you.
Okay. I'll just briefly address the supplemental authority he's talking about. And Fourth DCA says what it says. And, you know, with respect to them, I don't like disagreeing with an appellate court in front of another appellate court, but it's no surprise I disagree with them. I think the Fourth DCA has applied one of the more liberal standards when it comes to admitting loan payment histories, starting off with the Callaway case, which I think was a first. Even the Earhart on evidence is one of the most cited scholars on rules of evidence, cited Callaway as a departure from Florida law. They seem to, and I don't want to harp on it again, but they seem to allow not only for a subsequent servicer, they can testify that they don't know how their prior records were kept.
Has that issue been addressed here, though, also in the Vessels case?
I'm sorry?
The issue that was addressed in the fourth, then readdressed here in the Vessels case in 2017?
I'm not recalling the Vessels case off the top of my head, Your Honor.
Talks about loan payment histories of prior mortgages. Service providers are admissible as business record exceptions.
Correct.
Here in the fifth.
But I think if you look at, the reason why I'm even mentioning the Callaway is I think it illustrates a view that the Fourth DCA has on how liberal we should be with the admission of evidence. There they state that in there that it wouldn't even matter if the witness testified that they didn't verify the prior information because these things are inherently reliable. I would submit that that's pretty extreme when it comes to allowing evidence in that you could say the witness didn't even have to verify it and that they're inherently reliable. Then carry over to the supplemental authority they've gone a step further to say not only all that stuff, but you don't even have to produce the documents. That's a bridge too far that I'm asking this court not to follow. I want to address what the absurdity, what the absurdity of what's being asked in this case. The alleged prior servicer that we don't have any records for is Equifirst. Imagine if Equifirst showed up at trial in this case and said, back in 2010, this is the balance of the loan. But we can't produce our records to show that. There's no way the court would have allowed that testimony. There's no way you can enter a judgment on that. Yet 8 years later, a subsequent servicer is doing the exact same thing, saying we don't have the evidence. Just trust us. It doesn't make it any better. It makes it worse. And we're asking the court to say, if you're going to produce your loan payment history to prove a default in this case, you need to produce the whole thing, especially when your information is piggybacking off the information from a prior servicer.
In this case, was the alleged default date before or after a new servicer taking over the account?
The alleged default in this case was after the new servicer, after BSI came in. The problem, again, goes back to that default. I don't think they substantiated, but for the reasons I brought up about the default in their loan payment history, that it was recorded and reported and put together 1 year after that alleged default. So that's not sufficient. That's that's by definition doesn't fit the business record exception, so they can't establish that default date. But more importantly, a judgment doesn't just say when a default is. A judgment states what the amount of the judgment is against that homeowner. And when that relies on information that they can't produce to the court, it creates a big problem. Besides a legal problem, one of the equitable problems that I mentioned in my brief is that once a foreclosure judgment goes through, there is a potential for a default, a deficiency after that. If a judgment is for $200,000 and a home is sold for $100,000, the only thing the bank needs to do is file a motion showing what it sold the property for, and you can get the other $100,000 from that borrower, which is understandable, and I agree with that law. The problem is if you have excessive judgment based on information that you can't provide to the court, you're subjecting homeowners to potential excessive judgments that there's no way they can counter at that point because the judgment's entered. It's res judicata. All that's left for the bank to do is get their deficiency against the homeowner. And so I think the totality of the circumstances in this case is you have an amount that's based on a prior servicer. I'm repeating myself, I know it. It's based on a prior servicer's records that they can't produce. They have no idea how they were created. They didn't work for them. We don't even know that they actually had records from the prior servicer. We're just trusting them that they did. Then the records that they're relying on for the default were created a year later after the alleged default, and we're supposed to allow a judgment based on those facts. I don't think that's substantial competent evidence. I don't think it's competent evidence at all. We would ask that this court reverse the judgment. I think the case law shows where the bank, and I should mention that when we're talking about the amount of a judgment, this isn't a technicality. The law says that it's one of the elements they must prove. So it's an element just like any other element, any other cause of action. If you don't prove damages, if you can't prove it, you don't win. They can't prove with their evidence here, they can't prove the amount of this judgment, what it should be. Foreclosure needs to be denied. And the law that I cited in there says it's not a reversal for a new trial where you fail to prove your evidence on that element. The remedy on appeal is to reverse for dismissal. And that's what we're asking this court to do.
Okay. Thank you. Thank you both. And court will be in recess.